Okay, well, welcome everyone to this fourth and final installment of our HR Bootcamp for Healthcare Employers series. I hope that you have found these webinars to be helpful. The final installment of our series is an exciting one. We're going to cover paid leave issues that currently arise in the healthcare context, as well as some recent updates to wage and hour laws and thresholds. So, without further ado, I'm joined today by my colleague, Andy Bobrook. I'm sure many of you know Andy if you've worked with him on various labor employment issues and seen him on many webinars that we put out here at Bond. So Andy's going to be talking about a number of the topics with me. I will say as we get started, if you have any questions, don't hesitate to put them into the Q&A box. We will get to them if we have time at the end. So today's agenda, we're gonna cover a lot of material, including updates to some New York paid leave laws, including COVID paid leave, which I know many of you are asking about still, New York paid sick leave, New York paid family leave, and then we're going to talk about some wage and hour recent developments in the wage and hour world, including changes to thresholds and recent court decisions that are particularly relevant. So, without further ado, let's get started here. All right, so COVID paid leave. Just by way of review, COVID paid leave came into being in March of 2020. Shortly after the COVID pandemic began, the New York State Legislature passed a law which then Governor Cuomo signed, which required employers to provide paid leave to individuals who were subject to a quarantine or an isolation order relating to COVID-19. It applies to public and private employers, applies to full-time and part-time employees, and the way that you calculate how much leave was available to part-time employees differed a little bit than how you'd calculate what was available to full-time employees. The regulations provided that employers must provide up to 14 days of paid leave, depending on size. And a couple of things that have changed since the law was enacted. State and local agencies no longer issue mandatory or precautionary orders of quarantine. If you recall, at the beginning of the pandemic and for at least the first year of the pandemic, if you were exposed to someone or had a close contact with someone who had COVID-19 or you tested positive, you would get a physical order of quarantine or order of isolation from your local county Department of Health. They no longer do that. What we now rely on are self-attestation forms. The state has kind of given up requiring orders, and so employees can now fill out and complete these self-attestation forms and submit them to you in order to receive their paid leave. Here is the important note with respect to COVID paid leave. In the governor's statement of legislative priorities that was put out earlier this year, she said that one of the pieces of legislation she's going to be pushing is a sunset of the COVID paid leave law, which would, in theory, take effect on July 31st of 2024. Stay tuned for that. It has not happened yet, but we know that it is on the governor's radar and something that she is placing a priority on. So what benefits are employees who receive this COVID pay entitled to? They get their regular rate of pay, which is the rate or the amount the worker would have otherwise received during the leave period. This leave cannot be charged against other accruals, such as sick leave. You have to return the individual who is out on COVID leave to the same or a comparable job when they return. And the law prohibits discrimination or retaliation for taking this protected leave. The amount of leave available is going to depend on size. So for employers with 100 or more employees, you got to provide up to 14 calendar days per year of COVID leave. Now that is not 14 days of COVID leave, I should say. The regulations and the Department of Labor clarified that this only equals the amount of days that an individual would have worked during a 14-day period, which is 10. And then it reduces based upon size as you get smaller. Additional periods of leave, so some additional rules here. although the statute did not say anything about how many times an individual employee could take COVID paid leave, the Department of Labor has since issued guidance filling in some of these holes. So we know that the Department of Labor believes there are 3 periods of COVID leave available to each employee. Now, this doesn't mean if you assume you have to provide 5 days of COVID leave. This doesn't mean that an employee gets a cumulative 15 days of leave. This means that the employee gets 3 periods of 5 days. So, for example, if an individual only took 2 days in that first period, they don't have 13 remaining days. They have 2 remaining 5-day periods. I hope that makes sense. In addition, according to the Department of Labor guidance, the second and third periods of leave must be based on a positive test, and the employee must submit documentation from a licensed medical provider or testing facility attesting they've tested positive. We'll talk a little bit more about this in a minute, but that is what the guidance says in terms of providing proof of a positive test. Now, we know that also early on in the pandemic, I don't know if anyone is still doing this, but sometimes employers would say to an employee, you've had an exposure, so we're going to require you to stay home, even though you're not subject to a quarantine or isolation order. According to the state DOL guidance, if an employer does that, they are then on the hook to pay for that leave, in addition to any leave that would accrue if the individual tested positive. I don't, in my experience, most employers are not doing this anymore. They're not sending employees home just because they've been exposed. But the guidance addresses that situation as well. So as I mentioned, there is this potential sunset of COVID paid leave. If anyone wants to read about it, I've linked to an article that our firm wrote about the governor's legislative priorities. When you get the slides, I believe, Kathy, they're going to be available either tomorrow or the day after. When you get access to these slides, that's a hyperlink to our blog, and you can read the article there. All right, a couple of questions with respect to COVID leave that are the most common questions that I still get. Well, I should say the most common question I still get is COVID paid leave still a thing? Unfortunately, yes, it is. But these are the other most common questions. Do I have to pay COVID leave if an employee is positive but is able to work from home? So the answer is no, you don't. If the employee is positive but can work from home, they can work from home. You don't have to pay COVID leave. However, if they are unable to work from home, they're sick, they feel ill, you would still have to pay the COVID leave. All right, how much COVID paid leave must we provide? So first of all, it's tied under the statute to the period of quarantine or isolation. So right now, there is no period of quarantine following an exposure under the applicable guidance. So typically you don't have to provide COVID paid leave following an exposure. However, you do have to provide COVID paid leave following a positive test, and the isolation period under the current CDC guidance and state DOH guidance is 5 days. However, so that's why there's a but here. If an employee tests positive and remains symptomatic, you have to continue providing the COVID paid leave up to the statutory maximum. Neither the statute or the FAQs from the DOL address this, but an individual who stays symptomatic has to continue isolation, so you'd have to continue paying them. All right, the last most significant, most frequent question I get is, do I have to accept the at-home positive test? So again, there's no clear guidance on this other than what we see in the DOL FAQs, which says the second and third test must be based on documentation from a licensed medical provider. So there are a couple of different approaches that I've listed here. I think any of them is okay. If you wanted to accept an at-home test, you could, with nothing more. If you wanted to accept an at-home test with additional proof, you could do that as well. Or you could require for the second and third positive tests, actual proof of the positive test from the document from the facility. So those are your options. None of them are bad, but to answer your question, yes, COVID leave is still a thing, and hopefully it goes away on July 31st, 2024. And I can stop talking about it because I've been talking about it for the past 4 years. Oh, the last thing I wanted to mention is COVID vaccination leave. If you recall, there was a separate law that required employers to provide up to 4 hours of paid leave per injection for COVID vaccination. That law expired on December 31st of last year, so it is no longer in effect. All right, next up, we're going to talk about paid sick leave. And Andy, welcome. Thank you for being here, and we'll listen to your overview.
Great. Thanks, Adam. And kudos to you for putting this program together. I know it's been a great success and welcome by those who have attended. My pleasure to be with everybody here today and join my friend Adam in providing a little bit of information. I think a nice segue to this topic here, which I don't want us to lose sight of, is to go back to a question I got last week from a client. And the question was focused on COVID leave. The client had an employee who called and said, look, at my young daughter is sick, was tested externally positive for COVID at the doctor's office, tested positive for that. And I have to now quarantine and I should receive the COVID pay. Client calls me, says, hey, Andy, that's not right? It's only if the employee tests positive, there isn't this benefit any longer. Isn't that correct? I said, yes, that's correct. It's only the COVID benefit that Adam just talked about is only if the employee tests positive. And so there isn't some kind of benefit for a quarantine like there used to be once upon a time. However, we have to remember to tick through the list of other potential protected leaves that are out there when these situations come up. The example that I've used in the past is really to just have a checklist that we're going to march through every time an issue like this pops up. And one of those boxes that the employee could still be eligible for leave would be paid sick leave, right? If you have a sick child at home and where there's a positive COVID test, the child's not well, and the parent or guardian has to take care of that child, there is still the potential for paid sick leave eligibility. So just remember to not lose sight of this statute that we'll talk about here. And my sense from working with folks is, they haven't lost sight of it, but it's just kind of been folded into other policies, PTO, and it isn't as top of mind as some of the other compliance issues that are out there. And I think what we want to be thinking just from a conceptual standpoint is, let's make sure that if we have someone who falls into one of the criteria that makes them eligible for paid sick leave, that we're cognizant of us having an obligation to provide that leave to them, and that we are in some way tracking that. So we can avoid the situation where an employee says, oh, I was sick. I had someone else in my family who was sick. I was taking care of them. I was bringing them appointment, and I was denied this benefit. In that situation, we want to be able to have documentation set and ready to show, no, that's not the case. On that date, we did provide this paid leave. And I think that gets to it. And what I'm seeing in some circumstances is just, a lack of that kind of fine tuning with respect to how we're administering the benefit and how we're tracking things, because we're just providing, let's say, an abundance of PTO that employees can use for all reasons, including PSL reasons. And that's a compliant approach, but there's some nuance there that, again, I don't want you to lose sight of, and that's important here. All right, so just to back up a little bit, the paid sick leave applies to essentially all private sector entities, both for-profit and not-for-profit, as well as charter schools and private schools here in New York. Our legislators exempted themselves and all state employers and municipal employers from this requirement, but it does apply broadly in the private sector, applies to both full and part-time employees. And I think that's where, with respect to this being something new, I think it really is in the realm of part-time employees. And we worked with a number of employers when this statute was made effective back during the pandemic, really focusing on that issue and how to administer the benefit, in a fair way, but also in a way that protects the organization and business from unfair use. And again, the notion being that generally employers here in New York on their own have provided fairly extensive paid leave benefits in various forms, whether vacation, sick leave, or a combined PTO. but not necessarily for part-time employees. Again, how much benefit you need to provide depends on the size of your organization and the revenue stream. I'd say if we'll cover this in just a little bit with a slide, but generally the maximum amount based on size is 56 hours of paid sick leave for the permitted uses. That's every year that's provided. That has to be provided at their normal rate of pay. They don't define that in the statute. But I would say, a good rule of thumb would be to use the employee's regular rate of pay if they're non-exempt. If they are a salaried employee, right, computing the equivalent for an hour of absence based on their salary and their work schedule. And again, less of an issue, right, with somebody's salary who's receiving that fixed amount every week, because if they're out for 4 hours that day, the salary is going to be the same and continue. But let's not lose sight of tracking that 4 hours too. If somebody's out for a period, they need to be returned to the same or comparable job. Think about that much like the return to work obligations we have under the FMLA for covered employers. And again, we also need to be mindful that we can't discriminate or retaliate against somebody who's taking leave. And that's an important point to keep in mind too. Not that if something happens or we discover something while someone's on paid sick leave, or something happens either before or after they take sick leave, that we can't address that issue with the employee. We absolutely can, and we should. But what those kind of provisions and statutes that prohibit retaliation do is essentially put a premium on the review and the investigation, and especially the documentation that is derived from us addressing those issues, looking into it, again, wanting to give the employee an opportunity to address those performance issues or other specific issues, confront them with it, get their side of the story. But it puts a premium on us having that kind of documentation in place, so that if and when that employee subsequently says, no, this had nothing to do with my performance and my conduct, this was all about me being retaliated against because I took sick leave on a Friday and they were mad. Well, no, we can then pull out all that documentation, show that we conducted a fair, thorough investigation, reached a logical conclusion. A couple of issues that come up here with paid sick leave, the accrual. I think most of you hopefully are familiar with this. I haven't gotten too many questions of late on this issue, but again, there's really two ways to do it. Either you have an employee accrue 1 hour of leave for every 30 hours worked, or an employer can choose to front load the leave. And I see a mixed bag here from employers. And again, fair to say, and I know many employers out there who I've worked with have treated different employees differently, right? So they might have part-time employees accrue the time on a 1-for-30 ratio, and have other employees get the cliff vested or front-end loaded time. As I read the statute and have been familiar with the law, I think that's perfectly fine and perfectly okay. Of course, we can't be singling out folks in that regard based on any protected status, but alone as just a general issue, perfectly fine to treat different employee groups differently or different employees differently. Again, another issue of the carryover of unused leave, that is clearly required. There's a bit of a idiosyncrasy, I'd say, in the law here, insofar as, if we're going to front end load time each and every year for an employee, and we can cap their usage of that PSL time to, let's say, 56 hours, what's the point of having this carryover, right? So in other words, we're going to load 56 hours of time on January 1 every year. And if you don't happen to, and we can cap your usage of such time to 56 hours, clearly under the law, well, what's the point of carrying over 10 hours, let's say, of PSL time from 1 year to the next, if on that next January 1, you're going to get 56 hours of time? It's a great question. It's one we've worked with a number of clients on to address and make sure that they're comfortable. And there, I think that's an area where you want to work with legal counsel, make sure you're comfortable with the approach and the pros, cons, and risks that are associated with it. Okay, so permitted uses. I've been doing this job a long time. I don't believe I'm cynical yet, but this statute was drafted with extraordinary breadth in terms of what it covers. I've talked to clients on this before, and I think it could literally encompass a situation where I watched the Sunday night NFL game, I drank too much beer, I'm hungover on Monday, and I don't feel well and can't come into work. Again, it's drafted so very broadly that, again, I think it would be difficult for an employer to deny the leave based on that fact pattern that I give you there. So again, think of it as very broad, not only impacting the employee's health, but also the health of family members. And then New York City kind of created in the law itself 2 different buckets. They call the sick leave and the safe leave. New York entitled it just a sick leave, but there is this safe leave component where if somebody's been a victim of domestic violence or some other offense related to their person or their family member has, or they need to protect their family member from such a situation, there's this safe time leave that applies as well. And let me just touch on, with respect to the prior slide, in your policy, my practice, and I think the practices can differ, and I don't think you necessarily need to have this information in there, but I have generally included that kind of information in policies. I do want to have a generally speaking, a clear understanding for the employees in terms of what does qualify for paid sick leave and the safe leave. So typically in those policies, I will recommend including those provisions. So look at this. This statute came out when we were going a million miles an hour during the pandemic with one workplace change after the other. So if you haven't mentioned those policies, if you haven't taken a look at those policies in a while, and you may not have, I encourage you to do so, including if we're using our PTO policy to cover and check the box on this PSL. There's some issues that can come up there in terms of how much do we need to provide? What if an employee uses, we give them 80 hours of PTO that they can use for any reason? What happens if they use 65 of those hours to go on a 10-day vacation, only have 15 left? Does that satisfy our requirement to provide 56 hours of PSL? There could be some important issues to address there. And again, encourage you to dust off that policy if you haven't looked at it in a while, because this statute, unlike the COVID ones, is seemingly going away. This one's here, and I don't think this one's going anywhere. So I think we covered this here already. Hopefully this isn't a surprise to anybody out there, but again, the amount of time that you need to provide, including whether it's paid or unpaid, is going to depend on the size of your organization and the revenue stream. For very small employers with relatively small revenue streams, the leave is unpaid. So here you have this chart. See where you fall into it there. All right, so covered paid sick leave there, and Adam now is going to pick it up and talk about PFL. Adam?
Thanks, Andy. I appreciate it. That's a great overview. So we talked about COVID paid leave, paid New York State paid sick leave, now New York State paid family leave. So paid family leave, as I'm sure all of you know, applies to private employers. Public employers do not necessarily have to provide paid family leave, but they can opt in if they want. It applies to all employees who've worked a certain number of hours, 20 hours or more for 26 consecutive weeks, or worked fewer than 20 hours after having worked 175 days. So there is a threshold qualification requirement similar to what you'd see with FMLA. The deadlines and numbers of hours are different, but the concept is the same. Employers have to provide eligible employees with up to 12 weeks of paid family leave for permitted uses. We'll talk about what those are in just a minute. With respect to notice, this is a question that comes up quite frequently with clients that I work with. You'll get a call from an employee who has set up a situation that would qualify for PFL, and the employee calls in and says, I'm sorry, I have to take my dad to the doctor, or I have to do something that would be a qualifying event. They don't provide the 30 days advance notice that you are typically required to provide to obtain PFL. However, under the law and under the regulations interpreting the law, that isn't necessarily a bar to the employee receiving the benefit, because the statute says the employee has to provide 30 days advance notice for foreseeable leaves. So if a leave is not going to be foreseeable, the employee just has to provide notice as soon as practicable. The regulations say that this is typically within the normal procedure that an employer would require somebody to call in. So for example, if your facility requires an hour in advance of the shift to call in, that would normally be the time that we would be required if the leave wasn't going to be foreseeable. So that's something to keep in mind. The benefits that are afforded by the paid leave law include up to 12 weeks for permitted use. Similar to PSL and COVID leave, it's returned to the same or comparable job, continued health insurance, and I put a star next to this one. Discrimination and retaliation for taking leave is prohibited. What's interesting about the paid family leave statute is that there is a specific procedure for claiming violations of the paid family leave law. So if one of your employees takes paid family leave and they believe you retaliated against them for exercising that right, they have to go to the workers' compensation board, and they have to go through the workers' compensation board hearing process in order to pursue that claim. It's a strange procedure. It's filled with a lot of pitfalls for claimants and for employers. So I would encourage you, if you ever get a notice from the workers' compensation board about an employee who's filed a retaliation claim related to paid family leave, to reach out to counsel to help you out with that. Paid family leave may be available where an employee or family member contracts COVID. As Andy mentioned, paid sick leave might have been implicated as well. So you go through that checklist. One of the boxes that you should check and you should review is whether or not paid family leave applies. Permitted uses, again, there are enumerated uses that include bonding with a child, caring for a family member, and then there's definitions of family members, serious health condition, etc. One important point to note here is that unlike FMLA leave, PFL is not available for the individual's medical condition. Importantly, if an individual is going to take PFL to bond with a new child, that doesn't have to be immediately after the child is born, but it does have to be within 52 weeks following the child's birth or adoption. As you all know, I'm sure PFL is funded through payroll deductions. It is an insurance policy that is provided through your carrier. The amount that is taken out of your employee's compensation for this is capped at a certain amount that's specified by the statute and regulations. The employee applies for this benefit through your insurance carrier, and the amount that they receive is also capped. I will point out that Governor Hochul has also proposed adding paid prenatal leave in addition to PFL and disability leave. It would be a benefit of up to 40 hours to attend prenatal appointments or to deal with prenatal complications. If this is enacted, again, this is proposed. If it's enacted, it will take effect on January 1st of 2025. We will certainly keep you up to date on any developments there. One of the questions that I frequently get from clients deals with the interplay between FMLA and PFL. So they are different, they are separate leaves. However, at times they can run concurrently, and it gets confusing sometimes to understand when PFL is available, how much PFL is left versus how much FMLA is left. So here's a scenario to give us a little instruction on this point. So Karen takes leave to care for a grandparent with a serious health condition beginning in January 2024 for 8 weeks. How much PFL is used and how much FMLA is used. So interestingly here, caring for a grandparent is a qualifying event under the PFL, New York State PFL, but is not a qualifying event under FMLA. So Karen would be using, in this scenario, 8 weeks of PFL, but she would not be using any of her FMLA leave. So then in October of 2024, Karen's daughter has surgery and she needs 6 weeks off. How much FMLA leave does Karen have to use and how much PFL does Karen have to use? Well, with respect to FMLA leave, this would be a qualifying event under the FMLA. So Karen would have the full 6 weeks available under her FMLA. And actually, she'd have 6 more weeks available if she needed it. And she would have 4 weeks of PFL. Now, the key difference between PFL and FMLA leave is that PFL leave is paid, whereas FMLA leave is not. So Karen would only get the paid family leave benefit for that 4 weeks of that 6 week period. But she would still have remaining FMLA leave if she wanted to use it. So that's an interesting interplay. And if you have questions about that, don't hesitate to reach out. Okay, so now we're going to move on to something that I know Andy deals with quite a bit, and that is wage and hour rules. And there have been some recent updates we want to make you aware of, both in case law and in regulation. So Andy,
Thanks, Adam.
please explain this to me because I get confused with it sometimes.
All right, I appreciate you not referring to me as a wage and hour nerd. For the fellow nerds who are out there with me, with you, I think Adam referenced this as exciting at the outset here, and I don't want to poke fun at my good friend, but hey, we can get excited about wage and hour, and that's okay. So yeah, there's a number of changes that have been implemented here. I think we've talked about them on our weekly webinar. We've talked about them on our blog. If you don't subscribe to that, it's the New York Labor and Employment Law Report. And you can link to that right from our website at bsk.com. But we try to just give updates periodically on important issues, and these are issues that have been put out there as well for clients and friends of the firm. So again, what it is, big picture, right? The state here in New York continues to push up the minimum wage that applies to non-exempt employees, as well as raise the salary threshold that employers in New York, private sector employers. So again, if you are a public sector employer, or what I would say quasi-public sector employer here in New York, these requirements may not apply to you. But for private sector employers, they continue to raise the salary threshold that would apply to maintain exempt status for employees here in New York. Of course, we have the federal counterpart too that's out there, but for all intents and purposes, it's really going to be the New York law that controls here. These thresholds, this isn't a one and done type situation. These will continue to increase January 1 every year for the next few years, and I think we can expect after that as well. So again, give this some thought when it comes to budgeting, and if you're working on the finance areas tied to HR or have responsibilities, or you can clue in your finance leadership too, these are things that they should be aware of, because as these minimums continue to rise and rise, we see the compression with existing compensation that's already out there. All right, so the thresholds that went into effect January 1 are significantly higher than what's required under federal law, currently $684 per week. It's $1,200 in downstate New York, excuse me, $1,200 in downstate New York, which includes the city, and it's slightly lower in upstate New York at $1,124.20 per week. Again, these will continue to increase here. One interesting dichotomy between the New York labor law and the FLSA in this area is that New York actually does not have any minimum salary amount for bona fide professional employees. This being a webinar where we have a proliferation of healthcare employers is notable. Again, no minimum salary amount for professional employees here in New York to maintain their exempt status. All we need to do is meet their duties test. Now, with that said, there's an important caveat here to be mindful of. There still is the FLSA's requirement for professional employees, which generally is set at $684 per week. So we still need to make sure, in addition to the duties, that we're satisfying that minimum weekly salary threshold for those professional exempt employees under the FLSA. However, there is an exception from that exemption when it comes to teachers, doctors, and lawyers. There is no minimum salary amount for bona fide teachers, doctors, and lawyers under the FLSA. But every other professional in the FLSA still needs to meet that 684. A lot of information there. Just keep in mind, every time one of these exempt issues come up, be thinking, okay, what do I have to do to comply under the New York labor law? And then don't forget about the FLSA, and vice versa when you're analyzing these issues. Okay, we'll touch on this briefly, and chances are this may not have an impact in your particular area, but where you do maintain operations either in whole or in part that fall under New York's hospitality industry wage order, and to the extent that you have employees who receive tips as part of their duties, those thresholds have changed as well in terms of the amount of tip credits that can be applied. So in other words, the credits that we get against the minimum wage, we'd otherwise have to apply. For food service workers, that credit's higher than service employees. Food service workers, think about waiters and waitresses, hosts and hostesses, think about bartenders, captains, and the like. They are typically food service workers, and then kind of everybody else who falls within the industry and who receives tips customarily is a service employee. Again, just keep in mind these credits are limited if you fall in there. And this is an area too where the state has tried to compress those different jobs that employers can use to take credits based on tips they receive. I think that's kind of the one big important issue there. Okay. Before I go on, Adam, can we go back just 2 slides real quick here? So one thing I wanted to mention on this salary threshold increase. I've worked with a number of clients now. Every time this seems to happen, and really going back to when the FLSA under the Obama administration proposed a very significant increase. This is a time, as you look at your salaries for your exempt employees and make an evaluation. Hey, are we going to increase that salary? Are we going to create compression issues that we need to address? That's an important thing to consider too. But as you look at the position in the market and you decide, hey, are we going to increase that salary in comparison with, should we instead convert it to an hourly position and therefore pay overtime? That's something I know that our clients are looking at. And again, as these base thresholds continue to increase, becomes more relevant. Keep in mind, it's a good time when you do that to also take a look at the duties that are performed in that particular position and to examine those and to examine the exempt status of these employees. Because if, for example, you may have an employee who is going to be below the threshold, but maybe the duties are such that there's a question over whether they really meet the requirements for an executive or administrative employee here in New York. It could be an opportune time to reclassify that employee, hedge on that risk, and to do so without raising a red flag with respect to your analysis. Right here, it could be driven by the fact that there are these salary increases and that we had to adjust somebody's exempt status based on that. All right, thanks, Adam. Just wanted to cover that one point too. Okay, so I know I've talked a few times on this issue, and I know some of my colleagues have as well. It deals with New York labor law, section 191, and among other things, that law stipulates certain time periods that certain classes of employees must receive their pay. And for private sector manual workers in New York, it's weekly. And again, I think people think of manual workers generally as people in the construction industry, for example, or other areas of the like, but it has been interpreted much more broadly than that. Really, if it involves movement, lifting, I'm trying to recall some of the cases. I think a limo driver was deemed to be a manual worker in an opinion letter, or a case I remember reviewing once upon a time. Anyway, that manual worker applies quite broadly, and employees need to be paid weekly. And an interesting issue developed with a prior case on this, insofar as what if an employee receives all their pay, but they're not paid on a timely basis? And is there a cause of action that the employee has under Section 191? And I suppose this applied as well to the question of, well, if I'm not paid on a timely basis, and irrespective of anything else, do I still have a claim under 191? And there was a case years ago, the Vega case, that caught our attention at the time. And in that situation, the essential holding was, yeah, even if an employee received all their pay, there still is a potentially viable private cause of action under 191. And what could be recovered in those situations, of course, is not the pay, because they got everything they were supposed to receive based on the services rendered, but rather the equal amount of liquidated damages that's provided under the law. As you may expect, this caught the attention of the plaintiff side class collective action bar here in New York, and we saw a proliferation of these types of claims being asserted. Again, where an employee received all their pay at the end of the day, but just didn't receive it in accordance with the schedule set by Section 191 here on a weekly basis. So we put this information out there and tried to raise awareness of this. It was a good time to take a look at your practices. Now, from my perspective, I thought the Vega case really wasn't necessarily well reasoned in terms of the analysis that was there. It relied on some assumptions that I think were a bit of a stretch and were hard to justify. Move forward now to this year and a relatively recent case in the appellate division, which now created a split and ruled differently than the Vega case, and ruled that, hey, no, in that situation where an employee has been paid and received all their compensation, we're not going to recognize a separate cause of action to recover an equal amount of liquidated damages. And Adam, chime in if I have that incorrectly, but that's my understanding of the essential holding there. Still some uncertainty in terms of, hey, is there a private right of action under Section 191? I'm not sure that was squarely addressed, in there and definitively addressed. But now we have this split, and I think we're likely to see some kind of decision from the Court of Appeals that's forthcoming here. If the situation isn't remedied through the legislative process, and in that regard, there was a proposal in Governor Hochul's budget that would amend 198, which is where the private right of action and damages provisions emanate from the New York labor laws, pay sections, that they would exclude 191 claims from a remedy providing liquidated damages, which would effectively address this issue and put it to rest. And I think fairly in a proper way, consistent with how the statute was drafted and just general principles of fairness as well.
All right, Andy. Well, thank you. There was a question about a specific type of employee and whether or not that employee would qualify as a manual worker. I would say that with specific questions like that, please reach out to whatever bond attorney you work with directly, and we can answer that for you. It's hard to address specific scenarios on a webinar.
Yeah, I think that's best. Best to get legal counsel on those kind of issues. There's a lot that can go into that analysis. That's right.
All right. Well, I want to thank everyone for attending, especially those of you who have been with us through all 4 sessions. If you have any suggestions, or there are certain topics you'd like us to cover, or any webinars you'd like us to see present in the future, please feel free to reach out to me directly, to Andy. We really appreciate your time. We hope these have been beneficial for you, and thank you for being with us.